Welcome back to FE1 Made Simple, your trusted companion for mastering European Union law. I'm Jessica, and in today's episode, we're diving into one of the most technical, but also one of the most powerful pillars of the internal market, the free movement of capital. This freedom is unique among the 4 freedoms of movement. Why? Because it doesn't just apply within the European Union. It also extends to movements of capital between member states and third countries. That makes it one of the most liberally drafted provisions in the EU treaties. But here's the twist. While Article 63 TFEU opens the door to liberalized financial flows, this area of law has also become a battleground. Member states often seek to retain control over national issues like fiscal policy, public security, and financial stability. So while the freedom is broad in principle, it has triggered complex legal tensions, and that makes it a great topic for FE1 exam questions. In this episode, we'll break it all down. You'll learn the legal framework and scope of the free movement of capital, how to distinguish capital from other economic freedoms, the landmark case law that defines and limits this area, the key justifications and proportionality analysis under Articles 65 and 66, TFEU, and finally, a practical exam-style scenario so you can see how to apply the law under pressure. Whether you're reviewing a past paper or preparing for your first attempt, this episode is designed to clarify the law, strengthen your analysis, and help you craft answers that stand out in the exam room. Let's get started. Now let's turn to the legal framework and scope of the free movement of capital, centered on Article 63 TFEU. Article 63.1 provides the fundamental rule. All restrictions on the movement of capital between member states and between member states and third countries shall be prohibited. This broad language makes Article 63 arguably the widest reaching of the 4 freedoms. It is unique because it explicitly covers third country capital movements, a feature not shared by the other internal market freedoms, which are generally limited to intra-EU activities. But what exactly counts as capital? The treaties don't define the term, so the courts and legal practitioners turn to the 1993 nomenclature attached to Directive 88-361/EEC. This document lists examples of capital movements, including direct investments, such as in real estate or business shares, securities, like stocks and bonds, loans and credits, guarantees and sureties, personal capital transfers, including gifts and inheritances. The Court of Justice treats this list as illustrative rather than exhaustive. It provides useful guidance, but leaves room for interpretation to capture new forms of capital flow. A key distinction for exam purposes is separating the free movement of capital from other freedoms, especially freedom of establishment under Article 49 TFEU, which covers long-term business activities, and free movement of services under Article 56 TFEU, which applies where the activity involves temporary service provision. The Bars case provides helpful clarification. In Bars v. Inspecteur der Belastingen, the court ruled that if an individual's shareholding gives them decisive influence over a company, such as controlling management decisions, it falls under the freedom of establishment. If the investment is passive, for instance, owning shares purely for returns, then free movement of capital applies. Why is the scope of Article 63 so broad? The reason lies in the EU's commitment to financial integration. Free capital movement facilitates cross-border investment, enables individuals and businesses to access financial markets and credit in other member states, and contributes to macroeconomic stability across the EU. This breadth also explains why capital movement is often the subject of disputes, particularly where member states attempt to impose restrictions based on public policy, taxation, or national security concerns. In the next section, we will look at key case law and the most common justifications invoked by member states. Now that we've set out the foundation of Article 63 TFEU, which prohibits all restrictions on the movement of capital between member states and between member states and third countries, it's time to explore how the Court of Justice of the European Union has interpreted these restrictions in practice. In this segment, we'll break down the two main categories of restrictions, direct and indirect, and illustrate how they have been applied through landmark case law. This approach is essential for exam questions that ask you to assess whether a national measure affecting investments or financial transfers breaches EU law. Let's start with direct restrictions. These are the clearest and most straightforward violations of Article 63. They involve express legal barriers, where a member state's law directly prohibits or limits capital movements, such as restricting share acquisitions or requiring prior approval for foreign investment. A useful example is Commission v. Greece. In this case, Greece passed legislation limiting the acquisition of shares in national telecom companies and introduced a system of prior government approval for large-scale shareholdings. The Court of Justice ruled that this was a direct restriction on capital movement because it blocked investors from other member states from freely purchasing shares. Greece could not justify the restriction under Article 65 or any legitimate public interest ground. The takeaway is that formal restrictions on capital acquisition are almost always struck down under Article 63. Next, we turn to indirect restrictions. These are more subtle. They involve national laws or practices that discourage or deter foreign investment without outright banning it. A classic example involves the use of so-called golden shares. In Commission v. Portugal, the government retained special powers in privatized companies, including veto rights over mergers and asset disposals. The court found that even though these powers were rarely used, their mere existence created legal uncertainty, discouraging foreign investors. This indirect deterrent effect was enough to breach Article 63. Similar golden share arrangements have been invalidated in countries like Spain, the UK, and France, confirming the court's strict stance against state control mechanisms that chill cross-border investment. Finally, while Article 63 is broad, it is not absolute. Article 65 allows limited exceptions, notably for taxation, public policy, and public security. However, these exceptions are interpreted narrowly, and any restrictive measure must pass a proportionality test. A useful illustration is the Verkooyen case. Here, the Netherlands granted a tax exemption for dividends paid by Dutch companies, but not for foreign dividends. This discouraged Dutch investors from investing in foreign companies. The court ruled that the measure violated Article 63 because it was discriminatory and not objectively necessary to prevent tax avoidance. This case underlines that justifications under Article 65 cannot be used to shield discriminatory or disproportionate measures. In summary, for FE1 exam scenarios, always ask, does the measure directly restrict capital movements by imposing legal limits? Does it indirectly discourage investment through uncertainty or state influence? If a justification is claimed, is it proportionate and non-discriminatory under Article 65? These steps will guide you to a structured, high-scoring answer. Now that we've covered the types of restrictions under Article 63 TFEU, it's time to focus on how member states attempt to justify these restrictions, and more importantly, the strict limits imposed by the EU on such justifications. This segment centers on Article 65 TFEU, Key Case Law on Taxation and Public Security, the principle of proportionality, and the non-discrimination rule. This area is crucial for exams, especially in problem questions where you are expected to balance both sides of the argument. Let's begin with Article 65 TFEU, which provides the primary legal basis for member states to restrict capital movements. Under Article 65, restrictions may be justified on two main grounds: taxation, especially for preventing tax evasion; public policy or public security, to protect national interests. However, the Court of Justice consistently applies these exceptions narrowly. Even where a member state can claim a legitimate aim, the restriction must still comply with the principles of proportionality and non-discrimination. Taxation is the most frequent source of disputes. Problems arise when cross-border investments are taxed less favorably than domestic investments. A clear illustration is the Verkooyen case. The Netherlands granted a dividend tax exemption for domestic companies, but excluded dividends from foreign sources. The court found this discriminatory and in breach of Article 63. While taxation is part of national competence, it cannot be used to create unjustified barriers to free movement of capital. The takeaway is that free movement rules take precedence unless member states can provide a compelling, proportionate justification. In Marks and Spencer, the court took a more nuanced approach. The UK refused to allow cross-border loss relief for foreign subsidiaries. The court accepted that preventing tax avoidance was a legitimate aim, but applied the proportionality test, stressing that less restrictive alternatives must be considered. This case is a textbook example of how the proportionality principle operates in tax-related capital movement cases. Beyond taxation, public policy and public security are frequently invoked in cases involving state golden shares. In Commission Vive Portugal and Commission Vize Netherlands, member states retained special veto rights in privatized companies, citing the need to protect strategic sectors. The court rejected these defenses because the restrictions were either unnecessary or disproportionate. The golden share cases are especially useful for exam scenarios involving investments in critical infrastructure, energy, or telecommunications. The principle of proportionality is at the heart of the court's approach. Even if a member state invokes Article 65 successfully, it must still show that the measure pursues a legitimate aim, is suitable and appropriate for achieving that aim, and does not go beyond what is necessary. Most national measures fail not because the objective is unlawful, but because the means chosen are disproportionate or unnecessarily restrictive. For exam answers, here's a useful strategy. First, identify whether the measure is a direct or indirect restriction. Then assess whether there is a valid justification under Article 65 or case law. Finally, apply a strict proportionality test based on Court of Justice precedent. As a final point, where third country investments are involved, Article 64 TFEU may permit certain restrictions, especially in sensitive sectors, but it remains a narrow exception. With this structure, you'll be able to tackle both essay and problem questions with clarity and confidence. In this segment, we focus on an increasingly important area of EU law: capital movements involving third countries, regulated primarily by Article 64 TFEU. While Article 63 establishes a broad principle of free movement of capital, Both within the EU and with third countries, Article 64 introduces key limitations, particularly relevant in a world of shifting geopolitical tensions, post-Brexit dynamics, and national security concerns. Let's begin with the basics. Article 64.1 confirms that the free movement of capital extends to and from third countries. However, Articles 64.2 and 64.3 provide important exceptions. These allow the EU to adopt safeguard measures in cases of serious difficulties affecting the economic and monetary union, and introduce restrictions, particularly in sensitive areas like direct investment, financial services, or matters of public security. How does this work in practice? A leading case is Commission from Hungary. Hungary had introduced restrictions on the acquisition of agricultural land by non-Hungarian nationals, including third country investors. The Court of Justice held that although member states have more flexibility in regulating capital flows from third countries, discrimination based on nationality still requires justification. Even with third country investments, proportionality and non-discrimination remain key principles. Beyond case law, there are also practical mechanisms at play. One example is the Foreign Direct Investment Screening Regulation, EU 2019/452. This framework allows member states to review and block foreign direct investments from non-EU countries that may threaten security or public order. Importantly, it does not impose outright restrictions, but facilitates coordinated screening in sensitive sectors such as energy, defense, and critical infrastructure. This is particularly topical in the context of Chinese infrastructure investments and Russian capital flows following the Ukraine conflict. A further exam-relevant angle is Brexit. With the United Kingdom now classified as a third country, capital movements between the EU and UK fall within the scope of Articles 63 to 66 TFEU. Although the EU has not imposed general restrictions, member states may scrutinize UK investments, especially under national security laws. For your FE1 exams, here's how to approach a problem question involving third country investment. First, identify whether the restriction concerns portfolio or direct investment. Then assess whether the general freedom under Article 64.1 applies. Next, determine whether the measure is justified under Article 64.2 or .3. Always apply proportionality and non-discrimination tests, even in third country contexts. And finally, consider whether sector-specific mechanisms, such as FDI screening, may be relevant. In politically sensitive areas, such as energy security, strategic assets, or in the context of Brexit, these considerations become especially important and provide fertile ground for nuanced legal analysis in your exam answers. This completes our exploration of the free movement of capital under EU law. To conclude, let's apply these principles to a practical scenario, similar to what you might encounter in an FE1 EU law problem question, focusing on Articles 63 to 66 TFEU. Here's the hypothetical scenario. Emma, a German national, plans to buy residential property in Croatia. Croatian law requires non-EU nationals to obtain a special permit for land acquisitions. Emma also intends to invest 10 million euros in a Croatian tech startup, but a new regulation prohibits foreign investment in the tech sector, citing national security concerns about cyber threats. Meanwhile, a British pension fund is blocked by Spain from buying shares in a Spanish energy company, with the Spanish government arguing that it must protect strategic energy autonomy. The fund claims this restriction is discriminatory and breaches EU law. Let's break down the legal issues step by step. First, does EMMA's property purchase fall within the scope of Article 63? Yes. Under EU case law, such as Commission v. Portugal, the acquisition of real estate qualifies as a capital movement. Since EMMA is an EU citizen and Croatia is an EU member state, any restriction on her property rights engages Article 63 TFEU. However, if the Croatian restriction applies solely to third country nationals, it shouldn't apply to EMMA. If she is misclassified, for instance because of dual nationality or residence abroad, EMMA could challenge the measure under Article 63, relying on the principle of non-discrimination. Second, is Croatia's ban on tech sector investment lawful? For EMMA, who is an EU citizen investing from Germany, this is an intra-EU investment. Any restriction must be justified and proportionate, with a genuine security concern, following case law such as Commission v. Greece. If, however, EMMA invests through a non-EU company, Croatia could invoke Article 64 TFEU and the FDI screening regulation. Still, a blanket ban on an entire sector raises proportionality concerns and may fail if Croatia cannot demonstrate specific, case-based risks. Third, what about the British pension fund's dispute with Spain? Since Brexit, the UK is a third country, meaning capital flows between the UK and EU now fall under Articles 63 and 64 TFEU. Spain's restriction may rely on Article 65 TFEU, citing public security, but it must still pass the proportionality test and avoid discrimination. The Commission v. Hungary ruling shows that public policy claims cannot disguise protectionist objectives. The pension fund could argue that Spain's measure is a disguised restriction, especially if it lacks clear, targeted justification. For exams, the key points are: identify the legal basis under Articles 63 to 66, distinguish intra-EU and third country capital flows, apply relevant case law like Commission v. Hungary, Verkooyen, and the FDI screening framework. Always conduct a proportionality assessment. Consider the political and economic context, especially in sectors like energy, infrastructure, and technology. The freedom of capital movement remains one of the most dynamic areas of EU law, frequently intersecting with national sovereignty and external relations. By understanding the doctrine and applying it to real-world contexts, you will be well prepared to tackle both essay and problem questions on this topic with confidence.